Good morning, everybody. Thank you for being with us for our February Anti-Hate, Anti-Bias Task Force meeting. In the usual confusion that seems to infect every part of our daily life, you may have seen that last week on January 31st, President Trump issued a proclamation recognizing February as Black History Month. At the same time, his administration began taking steps to dismantle DEI initiatives across federal agencies and on college campuses. And as you know, we have 21 colleges and universities here in Middlesex, and the Dear Colleague letter that came out from the Department of Education last week, which is really how the department announces things that will change and how they'll be enforcing it, has just caused a lot of concern and lots of questions about where we're going to be. We know, of course, that Black history and its appreciation should not just be limited to February and recognized throughout the year, but the month still provides a time for reflection and education, whether or not the government is supporting that. And I'd like to particularly remember somebody who, to so many of us, was really a trailblazing figure, and that was Fletcher Flash Wiley, who passed away on February 7th at 82 years old. And he had a particular connection to our office because Tom Riley, who spent 8 years as the district attorney before coming to that spot, had worked in the firm that he started with Flash and former U.S. Attorney Budd. And that was really the first significant minority-owned firm in Boston. And one of the things I think that was really impressive about Flash Wiley is he had had a really trailblazing life. He was the first African-American ever from the state of Indiana to be nominated and to actually attend a military academy. He graduated from the U.S. Air Force Academy in 1965. And not only was he the first graduate from Indiana, but he was only the fifth Black man to graduate from the academy. And he was the first Black Fulbright scholar. He later got a law degree from Harvard and an MPP from the Harvard Kennedy School. And that really started him down that path of leadership and advocacy, which we were really benefited from here in Boston. He founded the Governor's Commission on Minority Business Development and served as the president of the Black Entertainment and Sports Lawyers Association because he continued to believe that he actually could sing and carry on and should be in that group. So he's just a wonderful, fun guy. He was a great help to us because he really believed in nurturing the next generation of diverse legal professions. And he created the Flash Wiley Mass Black Lawyers Association Legacy Scholarship Award. And I think one of the things that's important about Flash, and really as we look at this work, it wasn't just what he did or the barriers he broke or the work that he was doing, but he really paved a path of just continuing to care about these issues and working on them. He did an interview in 2020, and he said that he would consider any day that went by a failure if he had not done something to try to advance the position, either politically or business-wise, of African Americans in the city of Boston. And very intentional about that, a guy who could just, without being confrontational, just in the way he was funny or he'd break into a song or something, could just change what was going on. So I think as we look at this month and we're doing this work, it's important to keep that model in mind. And, you know, Massachusetts, despite the changes that have happened on the federal level, is continuing that commitment to racial equity and Black empowerment. And the theme for 2025 for Black History Month, which is African Americans and labor, highlights the really profound impact of Black Americans on the economic and social fabric of our country. And we invite you to use the chat today to share any events that you're having in your groups or your communities to celebrate Black History Month. I am really pleased to invite you to join us on an event that we are having on Sunday, this coming Sunday, February 23rd. We are going to host an event from 3 to 6 o'clock at Emmanuel College in Boston, and it's going to be a screening of the movie 688, which is the story of the first all women of color battalion to serve outside of the United States during World War II. It's an incredible story. Even if you can't come to our event, it's available on all kinds of streaming, so I commend it to you. It is a great movie anyway. It is just it's sort of like Hidden Figures. It's a story that's part of our history that people really don't know. And it talks about what they did, and it kind of relates to the labor piece. They were given a job that was considered really insurmountable, that was very critical for morale of soldiers, Black and white soldiers. It stars Kerry Washington, who plays Major Charity Adams, who led 855 women on a mission that people said could not be done. And sort of the struggles she faced as they continued to set deadlines that she wouldn't be able to meet and tried to force her into that position. We're then going to have a panel discussion with a number of very accomplished women who have shattered barriers in their own right. So the flyers in the chat, we really commend this to anybody, and particularly if you have contact with young people, high school and college students, please come. It's free. There'll be candy, there'll be a movie, there'll be a discussion. So it's all good. Good way to end vacation for many of our high school students. And on Monday, February 24th, we will be hosting a meeting of our opioid task force. Really, for the first time since the pandemic in person, it's going to be at the Alumni Auditorium at Lahey Hospital in Burlington. The keynote address is going to be given by former Mayor of Boston, Marty Walsh, who serves as the executive director of the National Hockey League Players Association, who will be in Boston tonight for the last game at TD North. And the focus of his remarks and our meeting is on the prevalence of substance use disorder among trade workers. And that has become an issue for us because our troopers assigned to our office respond to any death that occurs, whether it be accidental or on a job site. So they're going out to those. We've seen an uptick. There are numbers in Massachusetts for those kind of incidents are higher than the national average. And we know that just short of 15% of construction workers have been diagnosed with a substance use disorder, and that's 1.5 times the national average. And it compares to about 9% of all adults, so significantly higher. So the flyers and the contact information for that are in the chat. For those of you who joined us last month, you remember that we had an overview of immigration law. We talked about how climate control is a racial justice issue. Today, I'm really pleased that we're going to be talking about the legal definition and prosecution of hate crimes and civil rights violations. And I know we've talked about these numbers before, but in Massachusetts, the largest numbers of what are identified as hate crimes are directed at folks by race and ethnicity. 45% of the crimes that are prosecuted are about race and ethnicity. Just under 25%, 24.6% are based on religion, and 20% are based on sexual orientation. And Massachusetts has really robust hate crime laws that address criminal acts and civil rights violations. And as prosecutors, we have to be able to show that bias against one of those protected classes is what motivates the offense to secure a conviction. And it's also important to get the best results from an incident that we collaborate with our federal, state, and local partners. And those collaborations have included something we've talked about here at the task force. Massachusetts formed a state police hate crime awareness and response team, what they call their HART team, H-A-R-T. That really demonstrates the commitment of the governor and of the Commonwealth to enforce those laws. We've heard from that team. They're not here today, but they will be coming back to talk about how they're sort of responding to the changes in focus. Project Safe Neighborhoods, which we've also talked about, shows how we can bring federal resources to bear in a community, reducing crime. You may have seen today, there was a very significant arrest yesterday up in Lawrence and Lynn. a collaboration between the district attorney's office up there and the federal government, breaking up a gang that has really been terrorizing certain neighborhoods up there. And that goal of that partnership is really to attack on a number of different fronts, to use the laws that are available to us statewide and on the federal level to best prosecute those cases. And we also know, and we've talked a lot at this task force about the fact that for all of the hate crimes that we do know about, a huge number go unreported, either because there's a lack of awareness that something can be done, or there's fear about coming forward and saying something. And that disparity disproportionately affects vulnerable communities. So we really believe that knowledge is power. We hope that people will be sharing what they learn here. Also, remember to share our form that's available on our website where you can report anonymously. You can tell us about things that are crimes. You can tell us about things that are not crimes, but are just hateful incidents. It helps us to better use our resources. So I'm going to turn it over to our first speaker. And as I always am, I'm proud to have people from our own office talking about it. Dan Herron is an assistant DA in our office. He's been with us since 2007. He first came as a third-year law student to be a student prosecutor, loved doing this work, and came back to be a DA upon graduation. He's assigned to the Lowell Superior Court team, where he's done a great job investigating and prosecuting major violent felonies, including gang violence, shootings, robberies, and murder cases. And aside from all of that work, Dan has just really been a stalwart in our office in doing trainings for our prosecutors and for police officers. He just does a really good job of taking lots of information and then making it understandable and presenting it in a way that helps people to learn about that. And he does that on a variety of topics. Dan's a magna cum laude graduate of Westfield State and Suffolk University Law School. So Dan, thank you for doing this morning.
Thank you very much. I'm happy to be here. If I just have 1 second to share my screen. Can I just confirm if everyone can see that? So today what I'm going to do is just give an overview of Massachusetts hate crime laws. This isn't intended to be all-encompassing for everything that you need to know to prosecute it, but to give you an orientation in terms of what is out there when we talk about a hate crime law, a hate crime. District Attorney Ryan a few moments ago mentioned hate incidents, and that is a distinction that we have to deal with a lot of times where there may be something that occurs that is distasteful, that we don't like, but maybe does not violate a criminal statute. So I'm going to talk about specifically laws that are in place in Massachusetts that are geared towards hate crimes, as well as some other laws that we can have. My multiple screens, if you just bear with me for 1 second, please. Okay. So these are the topics. I'm going to give you what the definition of a hate crime is, and then keep that definition in mind as we're talking about each of the different crimes that we're going to talk about, in particular, the common crimes. So we have a dense statutory definition of a hate crime. Not going to ask you to read that. I just put that up here so that you can see it. But this is really what it breaks down to. When we're talking about what a hate crime is based on the statutory definition, we're talking about any criminal act. So again, it's a crime. It's not an incident that may be distasteful but doesn't violate our criminal laws. That criminal act needs to be coupled with overt actions motivated by bigotry and bias. So there needs to be a demonstration of the connection between that criminal act and what motivated the person to commit that act. We're talking about things that are threats. You know, I'm going to do X, attempts, I try to do Y, or completed, meaning I actually succeeded in doing it, towards protected classes of persons. There's an explicit list that was in that dense text that I just showed you a moment ago, and you'll see again on another slide. But there is an articulated groups of people rather that are included in hate crimes. And then finally, whatever was done, that criminal act that was done, needed to be done not only being motivated by bigotry and bias, but also with the intent to interfere with the person's exercise of a constitutional right through harassment or intimidation. So when you have all of those four factors, then you have a hate crime. If you don't have any of those factors, or if you're missing one of those factors, then based on our law, it doesn't qualify for a hate crime. I mentioned a moment ago about the protected classes. These are the classes that are delineated in the statute. So we're talking about racial, religious, ethnic, handicap, gender, gender identity, and sexual orientation. And as we get into two of the statutes in particular, violations of constitutional rights and assault or battery for purpose of intimidation, we'll revert back to this explicit group a little bit because one of the statutes has its own explicit list and another statute is more encompassing. So the first one that's probably the most common that you'll hear about when there's been a hate crime is a violation of constitutional rights. That statute breaks down to these four basic elements. So no person, whether or not acting under a color of law. That really just amounts to the fact that this applies to everyone. This applies to officials who are acting, government officials. This applies to private individuals who may be doing something. So it applies to everyone. I keep it in here because it is technically an element, but it's not something that really needs to be proved. Shall by force or threat of force. So when we're talking about force, we're talking about physically doing something that is capable of causing injury to another person. There's no specific definition for the level of force, and in criminal law, we have various levels of forces that are necessary to prove different things. So for an unarmed robbery, the law has told us it only needs to be very slight force so as to, for instance, pull a purse off of someone's shoulder, versus other force for when we get into things like armed career criminals, where it needs to be significant force capable of causing pain or injury. So there's no definition here, and I think that we could apply the lower version of force, but we do need to show that there was some force or threat of force that was used in the criminal act. It needs to be done willfully, means it needs to be done intentionally. It can't just be someone does a criminal act and then the victim happens to be part of a protected class of people. We need to show that they intentionally were trying to injure, intimidate, or interfere with that person, or that they attempted to do so, or that they threatened to or oppressed that individual. So we need to show the link between what they are trying to accomplish with their criminal act and the protected individual. And then it's any other person in the free exercise or enjoyment of any constitutional or statutory right or privilege. So as I said before, when we were talking about a hate crime, what meets the definition of a hate crime under Massachusetts law, we had this specific group of people or list of groups of people that are covered. And it's a broad group, and it would cover the vast majority of hate incidents and hate crimes that we would see. By this statute, including any constitutional or statutory right, it really is more encompassing. For instance, there are constitutional rights to housing. There are various statutory rights that we have that protect individuals in different environments, whether it be in school or things of that nature. And it's including both the federal constitution and the state constitution, as well as federal statutes and state statutes. So long as there is a provision that we can make a link to that person being part of a protected class, either by one of those two constitutions or one of those two bodies of statutes, if we can show everything else, then we can say that it's a violation of constitutional rights. So we're talking about people doing intentional acts with force or threat of force against another person to interfere, injure, or intimidate their exercise or enjoyment of their rights. The second most common statute that we see brought or charge that we see brought in these contexts is assault or battery for purpose of intimidation. I do a version of this training for law enforcement where I get into a lot more detail about breaking down each of these elements. We often talk about assault and battery. An assault is either an attempt to make contact with someone's person or a threat to make contact with someone's person. where a battery is the successful actually making contact with the other person. And so for this statute, an assault, meaning a threatened or an attempted battery, or a completed battery, is covered under the statute as one of the three elements. There's another version of prosecuting this for damage to real or personal property of another. And so it can also be accomplished by damaging someone's house, things of that nature. A link needs to be, like with the last statute, with the person's intent, that the intent must be to intimidate the person. So for the last statute, we were talking about to interfere or press, things of that nature. Here, it's purely to intimidate someone. And that intimidation needs to be because of the person's, and again, we have an explicit list of folks here: race, color, religion, national origin, sexual orientation, gender identity, or disability. So this is less inclusive than the last statute, because the last statute, we were talking about any constitutional or statutorily protected class of people, whereas here we have, again, a fairly broad brush of society, but probably doesn't capture everyone. And so to bring a criminal prosecution for assault or battery for purpose of intimidation, we need that assault or a battery or the damage to property, the link that the incident that occurred. So if it's an assault, that the person committed the assault with the intent to intimidate that victim because that victim belongs to one of these explicit classes of people. There's a lot of overlap between these two statutes. My slides got out of order. I'll go back to that one. So when I first started looking at this, and in particular looking at cases, discussing them, I said to myself, what is the difference? And I've hit on this a little bit, but just to look at it, violations of constitutional rights always require force or the threat of force, where an assault or battery for purpose of intimidation does not require force or threat of force when we're talking about damage to property. For violation of constitutional rights, the intent may be to injure, intimidate, interfere, oppress, or threaten. For assault or battery or damage to personal property for purpose of intimidation, the only intent that we can look at is that they were trying to intimidate the person. Then finally, as I've said, violations of constitutional rights is the broadest, encompassing all constitutional and statutory groups of people, whereas assault or battery for purpose of intimidation is only that explicit group of people that was included in the statute. Separate from that and somewhat related to assault and battery for purpose of intimidation, particularly for the destruction of property, we have destruction of a place of worship. So what this criminal offense is, anyone who willfully and intentionally, so they know they're doing it, they want to do it, and without right, wantonly and without cause, so they have no justification in doing what they're about to do, destroys, defaces, mars, or injures. And then I won't read it all to you, but we're encompassing a broad brush of religious and educational facilities. So for example, someone paints a swastika on a Jewish synagogue. They're doing it willfully and intentionally. They're defacing it. And it is a synagogue, which is included in the statute. That would then potentially be a violation of this offense. So it's a way of specifically targeting someone doing that kind of vandalism at a protected place. There is also threats to destroy. Oh, sorry, I did some last minute editing. Threatening to destroy a place of worship. So whoever threatens to burn, deface, mar, injure, or in any way destroy a church, synagogue, or other building or structure or place of worship. So someone who says that they're going to, shoot up a particular place or bomb a particular place. There are other statutes that could cover that conduct as well, but we do have in Massachusetts a specific statute targeting making threats of that nature. The public accommodations law has had minimal use in the criminal world. And really what this does is prohibits discrimination in public places. So you think about back to Jim Crow laws, separate but equal rules, segregation that used to occur. We do still have in the books in Massachusetts a law that prohibits people from being discriminated against based on being part of the protected classes that are listed in the statute and are on the screen here. More often, this comes up with MCAD complaints, which is Massachusetts Commission Against Discrimination, where someone will bring a claim there and it gets litigated there. And as I said, there's been minimal use of this that I've been able to find in the criminal context, but it still does exist, and it's worth noting that it's out there. As a prosecutor, my job is always to A, look at what happened. B, is what happened a crime? And if it's a crime, what are the appropriate charges to bring? And something that is worth considering is sometimes it's an easier burden where the government has the burden of proof beyond a reasonable doubt to prove each of these elements for each of these crimes that I've been going through. We have other crimes that are on the books that are used in a variety of contexts that sometimes it's easier for us to prove because we have a little bit of trouble maybe making that link between, their intended conduct was to intimidate the person because of their protected class status, or there's another link that gets to be more tricky to be able to prove beyond a reasonable doubt. So we can still prosecute hate crime incidents for other crimes that are not these specific statutes I've been talking about. They are other statutes that we use in other contexts, and we can still, provided we meet that earlier definition that I gave you of what a hate crime is, call it a hate crime, argue in terms of sentencing and disposition that it was a hate crime and a hate incident, but maybe we don't charge or prosecute one of those crimes that I've already gone through because we feel as though based on the evidence, we have a stronger case and are more likely to secure a conviction based on that. So that's something that we always take a look at is, what do we have the best evidence to be able to prove? What does the evidence support occurred here? But can we still make arguments that this was a hate incident or a hate crime connected to it? Something that also often comes up in these cases is protected speech, because what we do have and we see a lot of are words that are used. So fighting words is a category of speech that is not protected by the First Amendment freedom of speech. And those are words that are likely to provoke a fight, and it has to be face-to-face. So if people are on some social media and they're talking back and forth, then that doesn't fall underneath the fighting words exception. Because some people may say they have a First Amendment freedom of speech to be able to say what they said. So if they're saying it on social media, not face-to-face, we can't say the fighting words exception applies. However, if they are saying it to someone face-to-face and it leads to one of these incidents happening, then we can say it was not protected speech. There's true threats. So the person who's speaking has to communicate a serious expression of an intent to commit an act of unlawful violence to a particular group or individual. That can occur at times on social media or other types of platforms, phone calls, emails, text messages. So maybe if the language didn't fall under the fighting words exception, maybe it will fall under the true threats exception. And that's, again, something that we need to take a look at when deciding how to go forward on a case. Then finally, we have speech integral to criminal conduct. So that's speech or writing used as part of the conduct or violation of a valid criminal statute. So even if we're not fighting words, even if we're not threatening, but we're using racial derogatory language in conjunction with an attack on someone for purposes of intimidating them, maybe we haven't communicated a threat of I will kill you or I want to fight you, but the language that's used in the course of committing that crime helps to prove that intent that they're trying to interfere with the person's exercise of their constitutional or statutory rights, then that too is not protected speech. So those are things that we need to always look at in any of these cases for how does what occurred and what was said and done work with the First Amendment. So I'm happy to answer any questions either right now or later. This is my contact information. Again, I wasn't trying to dive too deep into the nitty-gritty of each of the elements, but just provide you an overview of the tools we have available in our criminal law.
Thank you, Dan. Questions, comments?
Melvin has a question in the chat. Can you outline the possible changes to the existing state racial protection laws?
I don't think I'm capable of answering that. I don't know, what's in the works for being changed. Sorry.
I think to Mel's question, the issue is going to be, I don't see the legislature making a big change really fast. The question will be whether the administration, I think, tries to sort of supersede Massachusetts law. Is it possible they'll issue an executive order? It's possible. I think they'll issue any order. The question will be what effect it has. And I think if that gets litigated here, we know that it will be different than if it's litigated in a federal court somewhere else. Anybody else? Questions, comments? All right. Jan, thank you. Oh, sorry. Go ahead.
Well, good morning, Dave, Ryan, and thank you for hosting this. And yes, you actually really touched on the direction I was going in, given the fact of many things that's happened around the country. I was just curious as to, did they see any legislative adjustment, change, modification to what was laid out today? And I guess maybe that would fall maybe more possibly in your lane, given your day-to-day interaction. So I guess you may have answered my question by saying you don't see anything at the moment, but do you foresee anything in the coming future? I guess would be the next question.
Yes. I mean, I don't think they're making any secret about this. I think they're going to keep chipping away. And frankly, I think, unfortunately, February is kind of giving them an opportunity to do that.
Thank you.
Yeah, do you see that question from Linda in the chat?
I actually can't see the questions right now.
All right. You know what? I think you have to stop screen sharing. Okay, there we go. Okay, let me see if I can get the screen. Okay, the question is,
Is the intimidation clause
the
new?
intimidation clause new? Did I hear correctly that if it in person, then it is a crime, but online is not substantial enough?
So in terms of the intimidation clause for violation of constitutional rights and assault or battery for purpose of intimidation, which also has that destruction of personal property for purpose of intimidation, the intimidation piece is not new. That has been in both of those statutes throughout their existence. The issue with online versus in person has to do with the First Amendment analysis. So First Amendment, people have the right to freedom of speech. People will often say distasteful things and then claim that they can't be criminally penalized for what they said because it was their exercise of their freedom of speech. Therefore, they have a constitutional right to be able to say and express themselves, and they can't be punished for it. So those three things that I was talking about at the end for fighting words, true threats, and speech integral to the criminal conduct it has to do with the First Amendment analysis for whether or not their speech was protected. So just to look at the question again, in person can be a crime and online can be a crime as well. It's just a different analysis in terms of exactly what was said. The one that does require in person is fighting words, which is speech that's made with the intent and very likely to result in physical combat, I think is the language that the Supreme Court has used. So fighting words requires it to be in person, but we still have those two other categories that very well can be online and get us over the First Amendment analysis. Does that answer your question?
No, not yet. Okay. Anybody else? All right, and you have Dan's contact information if you want to reach out, you think of a question later, or just let us know, and we'll forward it to him. Thanks, Dan.
All right, thank you.
There's one more
And-
quick question in the chat.
Oh, sorry. Oh, sorry, I didn't see that. Are you experiencing any change in the day-to-day enforcement in the police departments in the county? Yeah, what do you think?
I would say over the past several years, I've seen police departments be more attuned to this, particularly where it comes to hate crime reporting, things of that nature. So where I said I didn't get into the nitty gritty here, I've done a version of this training for a lot of law enforcement across Massachusetts that's longer and more in depth, where we get into more of trying to establish and prove each of these elements. So from that context, I've seen an increased awareness probably since 2020 across departments about these. And I believe now every department is required to have a hate crimes liaison or officer. I forget the exact term for it. So they seem to be more aware of it than in my past experience.
I think also, you know, in the last few weeks, there's been an increase in reporting. I think our departments, you know, we have great law enforcement partners, and I think they've done a really good job reaching out to communities, trying to be reassuring, trying to make clear things, for instance, like what the law is with respect to ICE and things like that. I think they've been doing a good job of trying to be realistic with people about their fears, given what's going on. One last question, is there plans to roll out more training given the current climate and growing risk? Yes, I think we do a fair amount of training. I think we'll continue to do that. And then, you know, the issue is, as far as the federal government, it's true, you know, I know a lot of communities have been trying to do trainings about things. What we've been saying to people really is we don't know enough yet. You know, if you line up the executive orders that have been issued, they change from day to day. So it's hard to do a training when the landscape is so different. So I think once we get to a place where we have a better sense, then yes, we'll continue with that. In the meantime, we're certainly going to continue our usual trainings that we're doing on those areas. Right? Anybody else? All right. All right, thank you. And
Thank you.
looking to our statewide partners, we're happy to have Jared Cohen with us, who's an Assistant Attorney General in the Civil Rights Division at Attorney General Campbell's office. He previously served in that office in their criminal appeals and white collar public integrity divisions. And before going to the AG's office, Jared was a assistant district attorney in Suffolk County. He was a litigation associate at WilmerHale, and he clerked for federal judge Barbara Crabb in the Western District of Wisconsin. Jared received his law degree from BU School of Law and his bachelor's from Cornell. So Jared, thanks so much for being with us today.
Thank you, DA Ryan. Very happy to be here. I hope everyone can hear me.
Yep.
I'm joining from my phone. I had some technical difficulties with my computer. Can everyone hear and see me? Who's going to help me share my presentation? There we go. Thank you very much. Again, I'm Jared Cohen from the AG's office, Civil Rights Division. I'm going to focus this on hate incidents, civil enforcement, and other resources. Hopefully not too much, since we're focusing on the civil enforcement side of things. So Antonia, if we could go to slide 2. Thank you. So let's start with some terminology here. Broadly defined, a hate incident occurs when someone threatens, attacks, intimidates, harasses, or otherwise harms another person because of that person's identity, including their race, national origin, religion, disability, sexual orientation, gender, or gender identity. Now, hate incidents are frequently going to involve speech. Some hate incidents may also constitute hate crimes, which Dan's touched on and we'll touch on again in a few minutes. And some hate incidents do involve hate speech. So what is hate speech? Third slide, please. Hate speech is speech that offends, threatens, or insults a person or group based on their identity. Hateful and offensive conduct and speech alone do not necessarily violate the law. Of course, we have the First Amendment. Free speech that is protected by the First Amendment cannot be the subject of an enforcement action. But hate speech may still be actionable in various circumstances. So just a few examples. For example, in K through 12 schools, a school can discipline a student for hate speech that interferes with another student's rights at school or causes a substantial disruption to the school learning environment. Also, some speech, such as threats and fighting words, as Dan alluded to, are not protected by the First Amendment. And even where hate speech is protected by the First Amendment, it can often be used as evidence that unprotected conduct was motivated by bias or hate. Nothing in the First Amendment prevents that. Next slide, please. So let's turn to the kinds of enforcement tools we have against hate incidents. Generally speaking, there's criminal prosecution, which is most frequently handled by district attorney's offices, which Dan has spoken about. There's civil enforcement under a number of statutes, most notably the Massachusetts Civil Rights Act and the anti-discrimination laws. And there are also other non-legal consequences for hate incidents that we're going to touch on briefly. Before we get into the Massachusetts Civil Rights Act, we're going to touch briefly on hate crimes. Next slide, please. So what is a hate crime? Dan and the DA's office has gone into greater depth as to hate crimes and particular statutes that criminalize hateful conduct. But generally speaking, for our purposes here, we think of it in a couple of broad ways. A hate crime is a criminal act or an attempted criminal act that is motivated, at least in part, by bias against the victim because of their actual or perceived protected characteristics or their association with others with those protected characteristics. And hateful conduct can be a hate crime even if the perpetrator is mistaken in believing that the victim was a member of a particular group, or if bias was not the only motivating factor for the conduct, as long as it was a motivating factor. Second, our law also includes a criminal civil rights violation, which I think Dan may have touched on, which is the interference by force or threat of force with a protected right, such as the right to vote or the right to access public facilities. And in general, local police departments investigate hate crimes, and local district attorneys' offices prosecute these crimes. So for the rest of the presentation, I'm going to focus on what we do in the Attorney General's office on the statewide level, which is mostly in the civil enforcement space. So next slide, please. The Massachusetts Civil Rights Act is an important statute that we enforce. It is General Laws, Chapter 12, Section 11H, 11I, and 11J. It protects the rights of all residents and visitors in Massachusetts against hate-based threats or attacks that interfere with their legally protected rights. Next slide, please. So the elements of the MCRA are conduct that first involves interference or intended interference. Second, with any right secured by state or federal law, including constitutional and other statutory protections. And third and key, the conduct has to involve threats, intimidation, or coercion. The law allows for a private right of action, but it also specifically authorizes the Attorney General's office to enforce the statute. Now, if we can go to the next slide, please. What can the MCRA address? It can address a whole host of conduct, including harassment by neighbors or landlords, bias-motivated threats and violence, interference with voting rights or access to reproductive health care facilities, Importantly, it can apply to both private individuals as well as public individuals acting under color of law. Next slide, please. And I want to briefly outline as well the anti-discrimination laws, which are General Laws, Chapter 151B. It's important to note that even though these laws are not explicitly described as laws against hate crimes or hate incidents often occur in housing, in the workplace, in schools, and in public spaces. So our anti-discrimination laws prohibit discrimination in all of these areas. So for a couple of examples, a person's rights may have been violated if, say, a landlord fails to protect a tenant from hate-based harassment by a neighbor, or if an employer fails to take action to address a hostile work environment caused by hate or bias in the workplace, or if a school fails to take action when students are bullied or harassed based on protected characteristics, or if a business fails to protect its customers from hateful conduct by its employees. Any of these types of actions may reasonably be thought of as hate incidents, and the Attorney General has the ability to take civil enforcement actions under the anti-discrimination laws to address this type of conduct. Next slide, please. And this was the anti-discrimination laws I was speaking about. Next slide, please. Okay. It's important to keep in mind that even where hate-based incidents and speech do not violate the law, do not constitute a crime, or may not even be actionable under civil enforcement laws, there may still be other consequences for hateful conduct or speech. So, for example, codes of conduct in the workplace, or in housing, at school, or on social media platforms may be violated. And reporting those types of incidents to administrators at any of those institutions can help trigger those consequences. So that's why it's really important to keep in mind the importance of reporting hate incidents, even in circumstances where they do not rise to the level of hate crimes. Next slide, please. So when it comes to reporting incidents, of course, in case of an emergency, 911 should always be the first call. To report hate crimes, contacting your local police department is usually the most important contact. As I think Dan mentioned, most local police departments these days have a civil rights officer assigned to handle hate crimes. And those cases are most frequently referred to local district attorney's offices to prosecute hate crimes where appropriate. Other places to report incidents, particularly if they may not rise to the level of hate crimes. The Attorney General's Civil Rights Division, my office, we receive complaints by phone, by email, and by automated online systems. So we receive a lot of reports every month, every week, really, about hate incidents. The Massachusetts Commission Against Discrimination, MCAD, MCAD, is also an important place to report certain conduct, particularly conduct that violates the discrimination laws in housing and employment and other settings. And then, of course, the FBI is also a good resource to report certain hate incidents. If I can have the next slide, please. Next slide, please. Thank you. So just a couple of highlights on our office's work, the work of the AG Civil Rights Division, because we do work in a number of areas that touch on hate incidents and hate conduct broadly. First, we bring cases, typically civil enforcement actions under the MCRA and the anti-discrimination laws, as discussed. We also issue guidance, most typically for schools, but also for some other institutions, to prevent and address hate-based incidents. We establish trusting relationships with communities and make referrals as needed. And we do sometimes conduct training for law enforcement, local officials, and community groups on how to recognize, address, and report hate. Next slide, please. So here's just a final slide with some more information. There's a lot more information in much greater detail than I've provided here at the AGO's website, mass.gov/AGO/no hate. I've tried to give a high level overview here and not go into too much detail, but there's lots more legal guidance, information, and other resources at the site there that I'd welcome you to access. And I'd be happy to answer any questions that anyone might have.
Thanks, Jared. Questions? Oh, here's a question, I think, from Linda. Jared, if the AG's office takes a case, does this protection cost anything for the target who's asked for help?
Does it cost anything?
Yeah.
No. I should note that, as I mentioned, there's a private right of action under some of these statutes. So individuals can, in certain cases, consult lawyers if they wish and pursue whether private action might be appropriate. But when they refer cases to the Attorney General's office, we are pursuing civil enforcement actions on behalf of the Commonwealth. There's nothing there's no cost to the victim or the person who reports it, but there may be an opportunity, even in cases where our office brings action on behalf of the Commonwealth, for a victim to collect damages and receive other remedies under the law. I may have skipped over this slide earlier, but just in addition to compensatory damages for a victim under the MCRA, there's also civil rights injunctions available. An injunction is a court order where the court may order the perpetrator to do or not do certain things. They may offer protection for a victim or others like them. They may require a perpetrator to stay away from a victim or a location, much as they are sometimes done in a criminal case. And again, monetary damages may be available for a victim, as well as civil penalties that a perpetrator may be required to pay to the state. But the short answer is no. There's no cost for a victim to report or speak with the Attorney General's office about a hate incident.
And those things can be happening simultaneously. So you could have the AG's office doing your civil injunction or seeking some other remedy, and you could at the same time be with your lawyer seeking to do something else.
Absolutely, that's a very good point, and that frequently does happen when when something happens and someone doesn't quite know how to respond and may want to respond on multiple tracks. Consulting a lawyer while reporting it to the AG's office or other authorities often makes a lot of sense.
Anybody have?
Melvin?
Val, did you have a question?
Yeah, just quickly, given the circumstance with the present protest, both with the Palestine, Gaza, Israel issue, and I know that the public schools have started making adjustments. Has your office seen an uptick in the number of complaints? And what would you suggest to be the action for parties who may feel that they, for some means, have been there's some sense of intimidation? What steps should they take in order to better provide information so that your office can do a investigation into any case of perceived racial bias or discrimination?
Yeah, thank you for that. So for the first part of the question, has there been an uptick? I'm not sure if there's been a measurable uptick. I don't know the exact numbers. I do know that we always receive a lot of complaints and referrals. I know that during the periods, for example, last year when there were a lot of protests on campus, we did receive a number of complaints relating to those protests. If a person feels like they've been threatened or coerced or intimidated in the context of political protests or any other activity, that certainly might fall into the category of issues that we can address. Recall I was talking about the Civil Rights Act, and it is limited in most circumstances to cases where threats, coercion, or intimidation are involved. So oftentimes certain types of unpleasant conduct can't be remedied under that. But again, if there is threats, intimidation, coercion, that could be either a private right of action under the MCRA or certainly something that our office can and frequently does look at. Whether it will lead to an actual civil enforcement action through a lawsuit, there's a lot of factors that go into that. Sometimes we may try to engage with the institution, whether it's a campus institution, higher education, or a law enforcement agency. There's a lot of factors that go into what the proper response is, but certainly civil enforcement action is a possibility under those circumstances. So people do report those types of incidents, and they should report them if they're experiencing threats, intimidation, or coercion.
If I could, I guess would be more either to you or to DA Ryan's office, if they could, like the other report, forward this presentation out, because I have interested parties I think would find this information very, very important and useful. So if there's a way to get this presentation, I would definitely appreciate it.
Are you good
Yeah,
with
we can
that,
do that.
Jared? Are you okay with that? Okay.
Yeah, we can do that. We can provide a public version either to your office, DA Ryan, or if anyone wants to send me, directly someplace that would like to receive it, I'm happy to do that.
Yeah, if you give it to us, we'll get it out to everybody on our list.
Great, thank you.
All right, another question. Let's see. If the AG's office, are undocumented people covered by the anti-crime incidents or crimes? Anti-hate, excuse me.
Yeah, that's a great question. And the answer is in most cases, yes. For the most part, the anti-discrimination laws, the Massachusetts Civil Rights Act, protect all residents in Massachusetts, regardless of their immigration status. So almost across the board, I can answer that with a yes. So certainly folks who may be, again, experiencing whether it's threats, intimidation, or coercion, or discrimination on the basis of protected characteristics, which includes in many circumstances immigration status, should not hesitate to report that conduct to our office. We do protect all residents and people present in Massachusetts, including visitors, regardless of immigration status. And we don't ask about immigration status, and we certainly don't share that information with federal authorities in this context. So absolutely, undocumented persons are protected and should feel free and encouraged and emboldened to report incidents to our office.
Another question. Is there a place where community organizations can find the data you're talking about and descriptions of things that have been reported about discrimination and harassment?
Yeah, I'm not sure about that. I don't think our office puts out public data. Certainly not real time about the volume and nature of the complaints that we receive, because frequently they are sensitive and they are confidential. But I can look into if there's some type of trends, data for the past few years, things of that nature that we are able to share. But for the most part, we don't put out public data on those types of complaints.
Many of the police departments do. We do a report every year to the legislature. We put those numbers out. It's not a real description of the events, but it breaks down what we report to the legislature. And a lot of the police departments on their public facing page put out, the activity of their hate unit or a hate officer. Anybody
And I
else?
think there are situations in which we can get folks data if they're interested. I think, as DA Ryan mentioned, it's the descriptions of the incidents that's going to be less available to review by the public.
Anybody else? Jared, thank you. Thank you for making time to be with us and for that good information.
DA Ryan, there's a question for you in the chat.
Oh, there is? I don't see.
How do you anticipate the 214 Dear Colleague letter from the Federal Civil Rights Office to affect public schools in Massachusetts?
I don't know. I think the schools are thinking very hard about that. I think that's something that's going to be reflective of the views in different communities. We have 361 towns, 51 towns. I would guess there'll be sort of a broad response to that. Anybody else? Thank you. Thank you. I want to thank everybody for being here with us. Thank you to Antonia for getting us all here together. Just a change as to the date next month. We're going to meet on Thursday, April 24th. That's a change from our normal date just because that is when the prosecutors conference is. and we'll all be at that. So please feel free to reach out if you have questions, you want more information. We'll make the slideshows, the public slideshows available to people. And again, thank you for being with us. Be safe, stay warm.